5 seconds to go. Start. Thus, it is a settled law that even if the plea of limitation is not set up as a defense, the court has to dismiss the suit if it is barred by limitation. The fact that the firm defendant number 1, namely Messrs. Shivraj Reddy and Brothers, was a partnership at will is not in dispute. It is also not disputed that one of the partners of the firm, namely Shri M. Balraj Reddy, expired in the year 1984. This event leaves no room for doubt that the partnership would stand dissolved automatically on the death of the partner as per section 42C of the Act. In the case of Devesh Nagalya dead and others versus Pradeep Kumar dead through legal representatives and others, this court held that in terms of section 42C of the Act, the partnership stands dissolved upon the death of the partner. The question of limitation in the admitted facts of the present case is a pure question of law and not mixed question of fact and law, because the fact regarding the death of one of the partners, that is Shri M. Balraj Reddy, is not disputed. This court in the case of Narne Ramamurthy versus Ravula Somasundaram and others observed as follows. We also see no substance in the contention that the suit was barred by limitation and that the courts below should have decided the question of limitation. When limitation is the pure question of law and from the pleadings itself it becomes apparent that a suit is barred by limitation, then of course it is the duty of the court to decide limitation at the outset even in the absence of a plea. However, in cases where the question of limitation is a mixed question of fact and law, and the suit does not appear to be barred by limitation on the face of it, then the facts necessary to prove limitation must be pleaded and issue raised and then proved. In this case, the question of limitation is intricately linked with the question whether the agreement to sell was entered into on behalf of all and whether possession was on behalf of all. It is also linked with the plea of adverse possession. Once on facts, it has been found that the purchase was on behalf of all and that the possession was on behalf of all, then in the absence of any open, hostile and overt act, there can be no adverse possession and the suit would also not be barred by limitation. The only hostile act which could be shown was the advertisement issued in 1989. The suit filed almost immediately thereafter. A fervent plea was raised by learned counsel for the respondents that the firm continued to exist even after the death of Shri M. Balraj Reddy and the business activities were continued by the firm. Even if it is assumed for the sake of argument that the partners were carrying on the business activities after the death of Shri M. Balraj Reddy, there cannot be any doubt that the firm stood dissolved automatically in the year 1984 as mandated under section 42C of the Act unless and until there was a contract between the remaining partners of the firm to the contrary. Stop.